Start. It is further submitted that even assuming that it was possible that the central government might be liable in a case of this nature, the learned Attorney General was right in contending that it was only proper that the central government should be able and authorized to represent the victims. Full stop. In such a situation, there will be no scope of the violation of the principles of natural justice. Full stop. The doctrine of necessity would be applicable in a situation of this nature. Full stop. The doctrine has been elaborated, in Halsbury's Laws of England, 4th edition, page 89, paragraph 73, where it was reiterated that even if all the members of the tribunal competent to determine a matter were subject to disqualification, they might be authorized and obliged to hear that matter by virtue of the operation of the common law doctrine of necessity. Full stop. An adjudicator who is subject to disqualification on the ground of bias or interest in the matter which he has to decide may, in certain circumstances, be required to adjudicate if there is no other person who is competent or authorized to be adjudicator, or if a quorum cannot be formed without him, or if no other competent tribunal can be constituted. Full stop. In the circumstances of the case, as mentioned here in before, the government of India is only capable to represent the victims as a party. Full stop. The adjudication, however, of the claims would be done by the court. Full stop. In those circumstances, we are unable to accept the challenge on the ground of the violation of the principles of natural justice on this score. Full stop. The learned Attorney General, however, sought to advance, as we have indicated before, his contention on the ground of de facto validity. Full stop. He referred to certain decisions. Full stop. We are of the opinion that this principle will not be applicable. Full stop. We are also not impressed by the plea of the doctrine of bona fide representation of the interests of victims in all these proceedings. Full stop. We are of the opinion that the doctrine of bona fide representation would not be quite relevant, and as such, the decisions cited by the learned Attorney General need not be considered. Full stop. We must have a clear conception of the doctrine. Full stop. It is well settled that the law permits certain things to be done as a matter of necessity, which it would otherwise not countenance on the touchstone of judicial propriety. Full stop. Stated differently, the doctrine of necessity makes it imperative for the authority to decide, and considerations of judicial propriety must yield. Full stop. It is often invoked in cases of bias where there is no other authority or judge to decide the issue. Full stop. If the doctrine of necessity is not allowed full play in certain unavoidable situations, it would impede the course of justice itself, and the defaulting party would benefit therefrom. Full stop. Take the case of a certain taxing statute which taxes certain perquisites allowed to judges. Full stop. If the validity of such a provision is challenged, who but the members of the judiciary must decide it. Full stop.